And during that four to 5 year period in which it was still leased, did the public schools still have liability exposure on that property?
What do you mean?
Well, if somebody, I don't know, went Columbine on it or something, could the public schools be sued?
Well, they could be sued, sure. You know, it was a triple net lease, as I recall, and so the Catholic schools picked up a lot of the burden of the expenses and obligations of the lease.
Right, but the public schools were still the owners.
Yes, they were.
Nothing further, Your Honor.
Any other questions?
No, Your Honor.
I saw that in the best offer process and timeline, you had a March 29 meeting of the Finance and Operations Committee, and then your recommendations would be sent to the Board of Trustees for their April 12 meeting. Right?
That's right.
Those were reduced to writing. How were they published?
Which were reduced to writing.
Your recommendations, as in sent means to me mail or email.
At the F&O meeting, the Finance and Operations meeting on March 29th, the recommendation was made by Dr. Clark during the meeting. So no recommendation was made in advance of the meeting, it was made during the meeting. And so being sent didn't mean the mailing of a written recommendation. It was being passed on to the full board for their discussion.
So in late March, the Finance and Operations Committee had their meeting, and the people that were submitting offers says they should be present, and they were.
Right.
And there was a discussion, and then did the committee act?
Well, the committee doesn't act. They don't take action. What they do is they pass along a recommendation to the full board to
Did they pass along, or did they formulate a recommendation and look around the table for nods or hand raises and
I
say?
believe they did, yes.
And was that reduced to writing?
It was not, except in the form of the agenda item that was, the formal agenda that was sent out for the April board meeting.
How would a person who was not at the Finance and Operations Committee know what the committee was going to recommend to the full board?
I think it was reported on in the Missoulian, and then the agenda for the full board would have gone out at least 48 hours in advance of that meeting in April.
And so when the full board met, they sent out the agenda and it said, we will consider whether or not we shall accept the following recommendation of the Finance and Operations Committee. Take the foundation bid.
Along those lines, it'd either be the committee recommends acceptance of this bid or the administration recommends acceptance of this bid.
So if someone were to look at the Board of Trustees agenda for the April 12 meeting, they would see that the committee had recommended take the foundation bid.
It would have either been the superintendent, or it would have either said administration recommends or committee recommends, but yes, it should be in the agenda.
Council, do you have any questions in view of mine?
I do briefly. Pat, isn't it also accurate that the minutes from the F&O meeting would have been posted on the district's website?
It would have. I'm not sure if they would have been posted in advance of that board meeting in April.
Okay. They would have been available in the board packet, though. Isn't that accurate?
Yeah, not necessarily, but they should have been posted on the website, but I just really am not sure that they were.
Okay. And isn't it common practice in the district to not only put out an agenda, but also have an explanation of the agenda as well, which contains supplementary materials?
Yeah, we identified background information, the information leading up to the recommendation, if there is one.
Okay, and all that information is available to the public as well, is that correct?
It is.
Any questions? Okay, thank you, sir. You missed it. What are we doing on time?
I was just writing you a note, actually. Plaintiffs have used 33 minutes, Loyola's used 76, and Missoula Public Schools has used 62.
You've got lots of time. You want to start using your time, so we'll make sure you get to use it.
You have another witness.
You're willing to take the chance that we'll run out of time, they'll use too much time? I will,
No,
if I were you.
You're right, Your Honor.
Call your witness. If we have time, we can.
Call Roy, Andy.
Just for the record.
Do you solemnly swear that the testimony you make will be the truth, the whole truth, and nothing but the truth, so help you God?
Just for the court's information, Mr. Andes has all of the exhibits with him. And I'll follow the procedure if the court approves it of simply referring him to them if there's an objection about foundation.
That'll work. That'd be okay?
It's fine, Your Honor.
Thank you. Please state your name and business address.
Roy Harold Andes. My business address is 32 South Last Chance Gulch, Helena.
What's your professional background?
I've been an attorney practicing in Montana for the last 31 years.
Would you detail your practice?
I'll detail it briefly. I started out practicing in Bozeman in a trial practice in 1977, then moved to Helena to serve as Assistant Attorney General for about 5 years. Subsequently completed a master's degree here at the university and practiced mostly in private practice then here in Missoula and in Helena since that time, with a brief period of time of about 3 years in which I served as Special Assistant Attorney General to the Department of State Lands with responsibility for trust land matters.
Okay. What was the nature of your practice generally?
And presently my practice, most of my private practice has to do with business, administrative law, regulatory issues, general business, and a fair amount of trust law.
State your background in trust law.
My first acquaintance with doing trust law issues arose when I was working for the Department of State Lands. I was one of several attorneys responsible for dealing with the issues of management of Montana's approximately 5 million acres of school trust lands and the state's fiduciary responsibilities with regard to those lands.
What is Mont Trust?
After I left the Department of State Lands, I came back to Missoula in private practice, and one of my primary clients at that time was an organization known as Montanans for Responsible Use of the School Trust, which is a public interest group, not unlike Good Schools Missoula. Montrust became an advocacy group which advocated for essentially improved management of school trust lands with the belief that with better management we could get more money for schools in Montana.
Have you ever lectured, taught, otherwise instructed on trust law?
I have. I've spoken at several national conferences on particularly beneficiary rights with respect to school trust issues in general. Most recently at the 2007 Anchorage Conference of the Western Association of Attorneys General.
Other than the current case, have you ever represented clients in major trust cases?
The major ones would be 2 Montrust cases. One I won and one I lost.
What did those involve?
Well, we don't have nearly enough time for me to tell you everything that they involved, but the first case involved the facial challenge of 12 statutes on the basis of being unconstitutional for violation of trust duties. We prevailed in getting 11 of those declared unconstitutional on their face at the district court and Supreme Court levels together. The second case was a more arcane question of trust law having to do with commingling of school trust monies into the general fund of the state, which from our point of view was a bad idea because we felt it ended up shortchanging schools.
When were you first consulted with respect to filing this suit?
It's hard to answer directly because I was consulting with the group of people that later formed Good Schools Missoula over a period of quite a number of months. And that began in, I believe it was summer of 2005, when I was representing one of the members of that group in another case with respect to District 1. And so in that capacity, I started consulting periodically every 2 or 3 weeks when I'd come to Missoula with the group that became Good Schools Missoula. And in those discussions, the issue of Roosevelt School and its sale came up frequently, and there's questions about are there legal venues or avenues rather that should be investigated. And little by little that discussion evolved into a discussion of litigation over a period of time.
What were the concerns with the people you spoke with about what it became the GSM suit?
Actually, you've heard them testify to today. Those were pretty much the same concerns that were expressed to me at the time.
That's essentially representative of what we've heard.
That's right.
Okay. Do you know how GSM itself came to be formed?
I think I can take credit for giving the advice that that was a good way to organize. Montrust had had a good degree of success using the corporate form of organization as a nonprofit corporation. The corporate form of organization as a nonprofit has a lot of advantages, and it just struck me as the appropriate way to proceed with something like this, and also as a vehicle for future involvement with promoting good schools.
Okay. Did you make an investigation of the factual matters before filing the case?
Extensively. I normally investigate cases pretty thoroughly before I file them, but in this case, I knew that the facts were very complicated. They took place over a considerable period of time and involving many, many players. So I did quite a number of things to investigate the facts.
Okay. Can you detail those for the court?
I'll do the best I can from my memory. Probably the first thing I did, of course, was to interview people who later became GSM members. I also then started interviewing other witnesses. Some of their names have come up today: Mr. Kouros, Mr. Abramson, former school board members. I interviewed at least 20 to 40 witnesses, and the reason I'm indefinite as to the number is that in many cases I would talk to them in small groups. And there might be 2 people there, or 1 person there, or 5 people there, and I can't remember. I wouldn't always necessarily write down everyone's name.
Over what period of time are we talking about now between the time that the notion of a suit concerning the Roosevelt sale to the actual filing of the claim? What was that period of time?
Wow, probably 3 to 4 months at least, because I'm a pretty demanding litigator in terms of what I want my clients to build in the way of a factual case before I'll file something.
Okay, so did you exchange notes with other written materials with potential GSM?
I did. The first thing, they were started out as very general discussions, and they involved getting more specific over time. But I started out, as I recall, by sharing a short treatise I'd written on trust law for lay people, specifically designed to acquaint people with school trust issues, since I was lecturing about that nationally. I shared that with GSM members, and I said, okay, if you think you got a trust case, show me the facts. And they started delivering me facts by the bushel, and I started digesting them and trying to fit them together and see if they made sense to me.
Did you collect and review any documents generated or published or generated by either or both of the defendants during this time?
That was almost entirely what I collected, were documents generated by the defendants.
Okay. Are those documents generally contained in the notebook in front of you, which is exhibits 1 through, say, 53?
Almost all of the documents in exhibits 1 through 53 were generated by the defendants, yes. There are a few exceptions that were generated in my office.
Okay.
And I don't think there are any other exceptions.
Okay. Did you examine the Roosevelt 1999 lease? I refer you to Exhibit 8 before you.
I did. I examined that. Actually, I examined virtually all of these documents except those which were subsequently produced in discovery, which is only a few of the total. Before filing, I examined most of these documents, the lease being one. One of the concerns that was expressed, as was expressed today, was the impact of this apparently below market lease on any potential sale of the property. And under trust law, that's a concern.
Direct your attention to what you've marked as Exhibit 18. Can you describe what that is?
don't have Exhibit 18 in front of me. It was already filed with the court about 2 years ago in our first response to these attorney's fee motions. That is a DVD consisting of, I think it's an MCAT video of the, well, I know it's an MCAT video that was taken of the October 26, 2004 Finance and Operations, what's it called, Finance and Operations? Yeah. F&O committee meeting.
Is that currently in the court file?
It's currently in the court file. I reviewed that before filing the case as well.
What was the substance of that meeting?
Well, the substance of that meeting fit together with all the other pieces because I reviewed many minutes and at least several videos of school board meetings, F&O meetings, to try and fit the pieces together. And that was just one piece of the larger puzzle. The significance, I guess, of that one piece is that it was fairly late in the process. And yet nonetheless, what you had very responsible members of the public, city council members, real estate professionals, coming and testifying before the F&O committee saying, you need to do a better job of this, you have a fiduciary duty. And what struck me in particular was how many times the word fiduciary was spoken to the board in that meeting. And I guess the other thing that struck me about that, and this goes to some of the other duties under trust law, is the apparent attitude that seemed to me to come across of the board members toward those people suggesting, gee, we'd like to make bids. And it was my perception viewing the video, and the court can judge for itself, of course, but it was my perception viewing the video that those potential bidders were seen more as obstacles than as opportunities.
Was this one of the ingredients that you based your recommendation to GSM on filing a suit?
It was one of many. Like I said, I've reviewed virtually all of the minutes that I could get my hands on with regard to Roosevelt over the entire time span, starting back with the lease discussions, involving all the way to the sale, and even subsequently. So this was one of the pieces. I wanted to review the MCAT videos in addition to the minutes to see if there were discrepancies, and probably unfair to describe them as discrepancies, but what I found were that the videos are obviously more complete than the minutes on a number of points that I thought were salient.
Okay. Did you review similar documents, procedures, and minutes from other school districts concerning sales?
Pre-litigation, yes. I looked at some proceedings from the Great Falls School District, yes.
Had there been a similar enterprise?
There had been a school closures and sales, as I recall, or a school closure and sale, I think it was. And I particularly looked at that because it was obvious to me, as it had been obvious in other trust lawsuits that I had brought, that this was going to be a case that required substantial expert testimony. And and one of the potential experts I had contacted prior to filing the suit was a state senator and former trustee out of this Great Falls School District. So I wanted to see what he was talking about when he talked to me about the procedure.
Can you name the experts you interviewed, and please describe what they were experts of or in?
Yes, I can. My hesitation is that I called a number of people as potential experts during that pre-litigation phase. I called a number of appraisers, most of whom said, Tom Stevens is a nice guy, I don't want to mess with him. And frankly, I wasn't convinced I wanted to attack Tom's appraisal anyway, because I thought he said some very important things in there that on their face the board ignored. So I mainly looked at other questions. And under trust law, an appraisal is an important thing, but it's not an end-all be-all, and that's consistent with the language that Mr. Stevens read out of the Appraisal Institute manual this morning. An appraisal is merely an estimate. To really get fair market value, you need to use a reasonable process, and that's what trust law holds. So I was looking at what was a reasonable process. So I was looking for witnesses who could talk about what was a reasonable process. And Don Ryan, who's then state senator and former school board trustee member, had considerable experience in Great Falls with the closure of the school. And I talked with him with respect to potential testimony about what an appropriate trustee would be doing in a reasonable manner. I also discussed this, let's see, I also discussed the same sorts of issues with in Helena, real estate
Mr.
developer.
Nicholson?
Mr. Nicholson, yes, Alan Nicholson. Long-term real estate developer in Helena who's developed many commercial developments in Helena, particularly using old buildings in many cases. His most recent development is the Great Northern Town Center, which houses the Carousel, the Multiplex Theater, the Great Northern Hotel, all those kinds of things. But he's also done many older buildings in Helena. In fact, he was my landlord for a number of years at my law office in Helena. So I wanted to consult him to see what a reasonable professional real estate developer might do.
You're familiar with the earlier case brought by Smith and Moody against the district?
I'm somewhat familiar. I did review it before filing this suit. I'm very sensitive to issues of res judicata and collateral estoppel, and so I wanted to make sure I didn't tread on the toes of litigation that had already happened.
What was your conclusion as a lawyer after reviewing documents in that file?
Well, I concluded that, with all due respect to those ladies, that their legal theories were not real good ones, but they had already learned that from the court. But I concluded that our case had no relationship whatever.
Okay, did you communicate that to GSM, its members, or the board? Or?
I did.
Okay.
To the members. The way it worked in the process was that I was consulting with a group of people who later became members once the organization was formed. And as I recall, the decision to litigate was made on my advice at a meeting of this group. And it was a decision of the members that we're going to do this. And so having decided to do that, they said, well, we better push forward and make sure our corporation is in place before we do anything like that. And as well as Mr. Andes, you go forward and prepare the case.
Did you look into the relationship between Missoula Catholic Schools, or Loyola, and the district?
Well, I did. I mean, that was an issue of concern because there were many questions about the lease, especially if the lease is below market value, encumbering the sale of the school. But if in fact they were two completely separate entities, that would be less of a concern because there would have to be rent paid from Missoula Catholic Schools to Loyola in any case. In other words, they would be on equal footing. Loyola would have been on equal footing with any other potential buyer. So I was concerned about that issue, so I did some investigating, yes.
Okay. I invite your attention to Exhibit 9. Can you describe what that is?
Exhibit 9 was one of the documents I examined pre-litigation. It's a document generated by Missoula Catholic Schools, and that simply spelled out Missoula Catholic Schools' exploration proposal for the purchase of this property and named a number of individuals as contacts for that purpose. So what I was doing here was trying to determine whether there was, at very least an agency relationship, if not an alter ego relationship, to use legal terms.
I invite your attention to Exhibit 28. Can you describe that?
Another document I reviewed pre-litigation, and I found this one particularly compelling because this was the overture letter from Loyola Sacred Heart High School Foundation to Dr. Clark proposing to purchase Roosevelt School. And I found the first line particularly instructive, which says, representing the Loyola Sacred Heart Foundation, the nonprofit fundraising organization for Missoula Catholic Schools, we have been authorized to enter into discussions with Missoula County Public Schools for the function of purchasing the Roosevelt School on campus, which struck me as being a fairly outright admission, as a matter of law, that Loyola Sacred Heart Foundation was the fundraising organization for Missoula Catholic Schools who run St. Joseph's.
Did you draft notes that are part of the exhibits? I guess I refer you to Exhibit 53, let's see, 50. 52 and 53.
Yeah, pre-litigation, I usually start taking a lot of notes, especially when I'm interviewing witnesses and reviewing documents. Particularly when there are as many documents and as many events involved as there were in this case. One of the things that I typically do in a case of some complexity is to start a timeline, which I did early on.
And that's exhibit what?
That's Exhibit 53, is the timeline that I started before I filed the case. 53 represents a later sort of iteration of that timeline, because what I do, I start a timeline, put dates, facts, exhibits in it, and start making sense out of it, and then as more information comes in, I supplement that timeline with more information. So in the case of Exhibit 53, this is an iteration that's dated December 16 of '06. Pre-litigation, this document was probably 5 pages long. In this iteration, it's about 6 pages long. But this is an example of the notes that I started preparing before.
Do I have that? 53?
53
Do your honor, it was in that original batch.
in that original packet we gave you this
Okay.
morning.
I looked through it, and I ended at 52, I think.
Well, I can share mine.
52 is the last.
Here's 53, Your Honor.
Thanks.
Okay. So that was the timeline that I started before I filed the case. Likewise, 52 is another example of notes. I haven't included all my notes here because that would be not only burdensome but boring. But 52 is another very short set of notes that I made on Mr. Stevens' appraisal. It's a short set of notes, but it took me probably half a day. It took me probably half a day to prepare Exhibit 52 because I was going over Mr. Stevens' appraisal with a fine-tooth comb and trying to fully understand what he was talking about.
Okay, what relationship do these last two exhibits have to any advice you may have given to GSM pre or after the actual formation of GSM? Why were they important as ingredients in deciding to make a case?
Well, I need to organize this volume of data and information, so this is part of the process of doing that. Having reviewed so much different information, minutes, correspondence, in a few cases videotapes, interviews with witnesses, interviews with GSM members, and notably, expert witnesses. I remember I did some other things pre-litigation, but that's all I can recall off the top of my head.
You also purchased the book, an outdated book as it turned out.
I did. I purchased that book. Hard to find.
Apparently. Before you filed suit, how many witnesses did you interview, and we'll run through the names. For those you don't remember, I suggest. Can you recall before you filed suit, the witnesses you interviewed?
As I said earlier, I think I interviewed some 20 to 40 witnesses pre-litigation. Not sure of the exact number because some were in groups. But certainly Mr. Corus, Mr. Abramson, I think I mentioned.
And what was Mr. Abramson?
He was the representative, one of the alternative bidders.
Okay.
He actually then merged his offer with Mr. Corus. I also talked with some of the people who'd worked with them in preparing their offers. I can't even remember all their names.
Did you interview Richard Smith?
I did.
And who was that?
He was also an author of an offer at some point in time, and it's escaping me how they all fit together at this point, but I knew that he'd been proposing an offer as well.
Did you interview former school board members?
I did.
Did you recall those names?
I can't off the top of my head.
Well, does the name Carol Bellins strike a bell?
Actually, I don't think I did interview her beforehand.
Okay.
I think I said I wanted to interview her, and I think one of the GSM members talked to her and said that she wanted to scrupulously observe the separation, if you will, and would be happy to talk with me later once she was no longer on board.
How about the name Teresa Jacobs?
Yes,
Okay, what, she was a school board member?
she had been, I believe.
Had
Yes.
Okay. Any other witnesses?
Oh, yes, I just can't remember their names.
Well, what
I
were
probably had a total of 15 or 18 interviews, some of them with individual people, some of them with groups.
so these would have been people who became or considering being GSM members and then also witnesses at school board meetings?
A mixture of both, yes.
Okay. What experts did you interview then before? So you've named Alan Nicholson, named Senator Ryan, any other experts?
As I mentioned, I did try and talk to some appraisers, but I didn't follow up on that at that time. Both Mr. Nicholson and Mr. Ryan agreed to testify, so that's why I mentioned them in particular.
How did GSM arrange to pay for their testimony?
They were going to volunteer their time.
Okay. What legal research did you do before actually filing?
Well, on trust law, I didn't have to do much because I had been practicing so many trust law issues over quite a few years. The one particular issue I was concerned about, was the fact that we did have a sale for a price higher than an apparently valid appraisal. Now, under trust law, an appraisal is not gospel because just as was testified earlier today, an appraisal is an estimate. An estimate is kind of like, as General Patton said, it's a battle plan. Every good general has to have a battle plan before you go into the battle, but if you're still following your plan 5 minutes into the battle, you're no longer a good general. So, an appraisal's like that. You've got to have one to start, but it's merely a starting place. And that's how trust law regards it. I recall in particular I think it's a Colorado Federal District Court case in which they voided the sale of the Denver Post by a trustee who relied on a perfectly competent in-house appraisal to make the sale to an insider. And as opposed to doing a legitimate long-term offering RFP type of process.
Has that case and other similar authority been provided to court?
They have, yes. I think they were provided for the first time in our motion for summary judgment on the issue of Good Schools Missoula's standing, and then they were subsequently provided in response to the first briefing on these attorney's fee motions, 2 years ago now? And then they've been provided again in more recent briefings as well.
On what basis did you conclude that GSM had a case, a reasonable case?
At trust law, there's a number of duties incumbent upon trustees. Actually, there's quite a number, a substantial number. The most important ones, particularly for this case, are the duty of undivided loyalty, the duty to obtain market value, and the duty to exercise reasonable prudence. The duty of undivided loyalty says that a trustee must exercise loyalty to the beneficiaries only. In other words, they must not give any benefit of the trust to themselves, nor any benefit of the trust to any third parties. In other words, no favoritism. And that's an absolute duty in which the courts very often simply toss out a contract or an act of the trustee on any showing, a facial showing of divided loyalty, regardless of whether there's even harm. The other duty, it was the duty to obtain fair market value. That's fairly self-explanatory. That's incumbent upon trustees to obtain fair market value. And then a third one applicable to this case is the duty of prudence. And that provides kind of a reasonable person standard. What would a reasonable trustee do in the management of this particular property in this particular circumstances?
At what point did you advise GM that it had a lawsuit?
Oh, probably just, my best of my recollection is probably just a couple weeks before it was actually filed. It's been a lot of time in preparation.
And can you summarize what you told GSM members of board of directors or whoever you were speaking with connected to GSM about your assessment of the case?
My assessment of the case was that there were a number of factors that suggested that what had happened here was a breach of trust, or at least a very reasonable case to show a breach of trust.
And what facts would you rely on? I invite first of all, your attention to Exhibit 19?
Well, in general, I relied on virtually all the documents I collected at that time, which was already some hundreds of pages. Exhibit 19 in particular, that was the exercise of the lease option. Given that there appeared to be a below-market lease encumbering the sale of this asset, it struck me that the circumstances of the exercise of the Catholic lease extension or the lease option were suspicious. It smacked of the kind of insider information dealing that I saw in that Denver Post case that I mentioned. You have the exercise of an option some 6 months after the primary lease term had expired. That caused me some concern. I said, well, gee, is that even a valid exercise of the option? So I had a paralegal do some research into it, and I reviewed the research, and it suggested to me that it was not valid. And I did some inquiry, I think verbally, to find out if the board, I looked at minutes, that's what it was. I looked at minutes of board meetings to see whether there was any indication that the board had questioned the extension of this lease. In particular, did they get a legal opinion as to whether they had to, because you had board members opining that we have to do it or we'll get sued, which of course you can always get sued. But I couldn't see that anyone had gotten a legal opinion as to whether they had to exercise that lease extension or not. And from my research, it showed that they didn't. So that was a concern from a trust standpoint.
What's Exhibit 23?
Exhibit 23 are minutes of the Board of Trustees meeting December 14, 2004. And this was the extension of the granting of the extension of that lease option. It's discussed on pages 4 and 5 of the minutes of the Board of Trustees. And even though one of the board members was saying we'll get sued if we don't extend it, you did have people advising that now there's a question here. What's this going to do to the potential sale of the property if this lease is in place?
What are Exhibits 2 and 3?
2 and 3, again, are Missoula District School documents, which to me corroborated that there was at least a very legitimate question whether this lease was market value or not. In both cases, they were indications, one by Larry Johnson in Exhibit 2, that it should bring $8 to $10 per square foot for leasing the school. In Exhibit 3, a memo to from Mary Wagner, then superintendent, suggesting that the reasonable rent for Roosevelt School was projected to be from $80,000 to $140,000 a year. This is back in 1998. So that certainly suggested an issue with regard to the reasonableness of it.
What is Exhibit 5?
Exhibit 5 was a letter to Superintendent Wagner from Lance Melton, General Counsel of the School Boards Association in Helena. And this was essentially legal advice, since Mr. Melton is, he's General Counsel, saying, as I viewed it, warning the district, make sure you're getting fair market value for this lease. So they were on notice. This goes to the reasonable person standard, of course.
What are exhibits? Excuse me. What are Exhibits 6 and 7?
Exhibit 6 are the minutes of the special meeting of the Board of Trustees, Missoula County Public Schools. And this was the meeting in which the original 1999 lease to Missoula Catholic Schools was approved. And I noted again that there was dissent suggesting that we could get more money for this. This further corroborated the issue of fair market value.
We've heard testimony about the rushed sales process or the perception of it as such. I invite your attention to Exhibits 31, 35, and 38. Can you describe those?
Well, these also, at this point, all of these were required before the lawsuit was filed. Under trust law, what a reasonable trustee would do, of course, is obviously a sliding scale. It depends on the circumstances, but so these are not easy cases to prosecute or to defend for that matter. But this was part of the cumulative evidence, these 3 exhibits, tending to show that the process was rushed. When you rush a process, you defeat your chances of getting really good offers. They were all school district exhibits, I believe, or documents.
I invite your attention to Exhibit 12. Would you testify about that to the court?
This memorandum from Superintendent Clark to the F&O Committee and the trustees, May 22 of 2003. Second page, second paragraph. Dr. Clark is advising that the sale of Roosevelt needs to be acted upon at the June board meeting if we are to fulfill the request of Missoula Catholic Schools. I just took this as more corroborative evidence of the process being pushed in a somewhat questionable manner.
Okay.
Whenever you would find it convenient to take a break, we can do that.
Yes.
Now, okay, we'll take a 15-minute recess, please.
Conduct that's been described of Loyola, trying to rush the decision, I refer you to any statements made by the appraiser, Ted Stevens, or Tom Stevens, to that effect, that was ignored by the board.
Yeah, if you look at Mr. Stevens' appraisal in Exhibit 15, I believe it is, there are a number of things that I thought he gave some very good advice in there about what you want to do to get the best price for this property. And let's see if I can find the pages through it here. On page 11, he offered an opinion, very last sentence on page 11 of the appraisal. Due to the subject's uniqueness, an exposure period of near 1 year would not be unusual. And in fact, what the exposure period here was from the time they first published notice in the newspaper, and I believe it was December, until the sale was closed, was a period, I mean, the total period from start to end was what, 3.5, 4 months approximately, which struck me, I mean, that's not inconsistent with the 90 to 100 days he talks about just above it, but given his opinion with regard to this particular property, that struck me as rather fast. His advice was also apparently ignored, not apparently ignored, it was not used at least. On page 12 of his appraisal, he says, the highest and best use then would be continued use of the educational improvements for grade school, but develop the land fronting Stevens Avenue with single-family home sites. And of course, that was not followed either.
I refer you to Exhibit 37 concerning Pat Hughes' statements.
Exhibit 37, actually Exhibit 37 is probably goes in a pair with another exhibit, is it 38 maybe? Yes, it is Exhibit 38. This has to do with Mr. McHugh's estimates as to comparing the two apples and oranges offers he described them. And he's correct, they are apples and oranges offers. But he did describe the one, Mr. Corus' offer, as being worth ultimately about $220,000 more based on his best estimate. What's significant about that, however, more importantly, is the statement that the minutes reflect Mr. Corus making in response, which are on page 5, actually immediately above that. It's the first, well, it's the second, the second paragraph on page 5 of the minutes of the school board meeting of April 12th. And Mr. Corus is quoted as saying there, seemed like a bit of a rush at the last. He said, I could have worked out another form of credit, but we didn't have the time. Now I'm paraphrasing here because I reviewed the videotape of this meeting, and Mr. Corus' comments are considerably more lengthy than they appear here in the minutes, and describe in more detail what the problem was with the rush procedure that prevented him from making an actual cash offer at that point.
Yeah, I refer
We have the video, the DVD of the August 12 meeting, I think, sitting on the table. We haven't marked it as an exhibit, but it would be probably appropriate for court review if the court wishes
Should
to
this
do
be
so.
exhibit 59?
It's not marked.
Would be 59?
Well, I guess, I would object on the basis that we haven't actually seen what it is you're talking about. Do you have copies?
It's the MCAT videotape of the April 12, 2005 board meeting at which they approved the sale of the school.
Is it in the file somewhere?
No.
I don't believe it is. This is the only copy I was able to obtain.
What's your question?
Question is, did you have an actual recording of Mr. Cruise's remarks at length?
This DVD is a DVD of the entire board meeting of April 12, 2005.
Where did you obtain it?
I obtained it from MCAT,
Okay.
and I reviewed it myself.
All right. Does it accurately portray the, you weren't at the meeting?
I wasn't at the meeting, but I didn't see any edits or dips or beeps or spits.
Your Honor, I'm going to object on foundation. This witness can't establish the foundation for the video because he can't indicate whether or not it's a true and accurate copy of what occurred at the meeting.
You say that it's a made-up one.
We haven't seen it, Your Honor. We don't know. We don't know what's
Why
being
don't you
presented.
look at it at your convenience, and if you object to it, you can note your objections, but I won't admit it now.
I'll need a copy of exactly what it is they're turning into you then.
So there'll be, you have a copy to keep, I have a copy to keep.
Wonderful.
We need two.
Probably 3 for Mr. Schneider.
Actually, Your Honor, I don't really care.
You can share. All right.
Thank you.
So you make the copies and distribute it to them, and if you don't have an objection, you admit it.
We'll surrender the original to the clerk. Thank you. Referring you to Exhibit 22 and the question of this having an open bidding process, standard RFP.
This was back in November 30th, 2004, shortly after the electorate had approved the sale of the school. And this, Exhibit 22, are board meeting minutes of the Finance and Operations Committee. And there were considerable discussions throughout these minutes in which the advantages of an RFP were discussed, and ultimately Dr. Clark was recommending it against it for various reasons. The minutes also reflect Ms. Rabine asked a question, a very good one: would the new owners of the building have to honor the current lease to the Catholic schools? And her question was answered at that point in time. So it is further evidence that I had pre-litigation concerning potentially unreasonable procedure from a reasonable prudence trust standpoint.
These are all ingredients of your decision that there had been a breach of trust.
Yes, I acquired all this information we've been talking about in pre-litigation.
Okay, was there cooperation after you filed the suit through discovery?
There was, actually. This is what lawyers like to see. Discovery proved to me that my case was even stronger than I thought it was.
Okay. I invite your attention to Exhibit 30 and remind you that we don't have much time.
Exhibit 30 is, it says LSH at the bottom, indicating it's a document I received from Loyola in discovery. It appears to be a letter from someone at Loyola, unnamed because it's not signed, to Missoula County Public Schools, attention Bruce Moyer. And what I found particularly compelling were the arguments on the, let's see, next to last page, is it? Third to last page, in which the writer of this says there is a negative lease encumbrance because the lease fails to adequately provide for a return on investment. For the next 4.5 years, the investment fails this basic economic requirement, and a discount to an encumbered fee simple value is required. This is an indisputable fact. Of course, this discount only applies to other investors and not to Missoula Catholic Schools, because as tenant, we are the only potential investor that can use the property immediately for our intended use.
What's Exhibit 46?
Your Honor, we object to the admission of 30. There's no foundation for it. We don't know who the author is.
Who is the author?
I don't know, Your Honor. It actually looks like perhaps it's a draft.
It's extremely well written. And isn't anybody going to clear it?
By way of foundation, I obtained this document directly from Loyola Sacred Heart Foundation.
Yeah, we don't dispute that it's probably a draft letter, and in fact, there probably somewhere is a final letter, but this, I just don't see any relevancy. It's a draft letter.
Did the Missoula County Public Schools ever receive this?
Not that I know of, Your Honor.
And you looked? You looked and asked?
I reviewed this document, I saw this document in the
No,
discovery.
the question was, you looked and asked?
I was going to ask. No, I looked through and did not see it, so I assumed it was a draft that was not sent.
Let's say, you looked through all the files of the Missoula County Public Schools, you did not see it, and you asked all people who could have received this, including Bruce Moyer, if he received this.
No, when I saw the letter that came through the discovery, I went back to Bruce Moyer's file at that time. He was no longer employed with CPS. I went back through his file and back through Mr. McHugh's file and did not find this letter.
And who else did you ask?
Pat McHugh. I also reviewed his files that he inherited from Mr. Moyer.
So you think, are you suggesting this, somebody wrote it, and then they waited a day and looked at it and go, ha, I'm not sending this one?
No, that's not it, Your Honor. I mean, basically, I just don't understand the relevancy of it.
No, I think, look, can I help you with that?
Sure.
I think what they're saying, correct me if I'm wrong, is that this looks like a letter from the foundation saying, you should take our offer.
And that's relevant in what way to a legal claim?
In that they are, this goes to support the plaintiff's, I'll call it, I would call it the conspiracy theory. You would make,
That's what I...
They're very close. They're very close.
I think that supports their conspiracy theory that,
Well, as I checked, Your Honor, Bruce Moyer, as far as the testimony today, never sat on the public school board. So I question the relevancy of Loyola Sacred Heart Foundation, if that is who sent the letter, writing a letter to Bruce Moyer, and how that relates to any legal claim in this case.
Well, I think this goes to show the relationships among the three parties. They may well hide behind particular legal structures, but in fact, as the court noted very early on, this is a sweetheart deal.
no, I noted early on that you claimed it was a sweetheart deal.
Very, I stand corrected.
And I think it's important that there be some, at least some preliminary showing that it was drafted by someone that is associated with the foundation, or alternatively, it was received by someone at the public schools, other than maybe someone on your side who wrote it.
Well, we can't write that well, Your Honor.
So I'm concerned that you haven't got a foundation for it.
Okay.
If I may, it's not the only document that so shows. We also acquired and discovered Exhibit 46, which is filed under seal with the court, so I can't comment on as to its contents, but I'll simply refer the court to it.
Exhibit 46.
And that is signed via an email, Exhibit 46.
And again, I'll object to this as relevancy. What is this relevant to any claim that's filed in this case?
Bona fide purchaser defense, which you've raised over and over again.
This appears to be an email from nobody associated with the public schools.
Not public schools, it's Loyola Sacred Heart Foundation. John Giuliani was on the negotiation team.
So are you claiming that there was some legal duty for the foundation not to speak to the individuals that are listed on this email?
I'm claiming that they knew they were getting a sweetheart deal.
And they had some duty not to get a sweetheart deal?
No, that they knew that they were getting something that was below fair market, and that is a breach of trust, which they had knowledge of.
Hang on.
They had a legal duty to not get a purchase below fair market value.
They had, no, you've raised the bona fide purchaser defense. I'm showing these documents show they were not bona fide purchasers. They knew they were getting a deal that was below market.
And is there somewhere in here that talks about buying the property for less than $1.45 million?
Not that I'm aware of.
Then I don't see the relevancy, Your Honor.
Actually, there is. I think 46 says that, but I'm not allowed to testify to it.
Where's it sit at? I'm looking
First
at it.
paragraph, Your Honor.
Which one?
I think it's the first paragraph there. Reference to Steve Hall.
Yeah, that's the under market encumbrance of the lease. Is that what he's referring to?
You're looking at 46, Your Honor?
Yeah. First paragraph, right under good morning.
Right? Yeah, my point was that there's nothing in here that talks about anything below the $1.45 million offer. And also, if we're going to get to that point, Your Honor,
A second. You said what in here showed it was a sweetheart?
The knowledge by Loyola Sacred Heart that this lease encumbrance was below market. That
Oh, the lease,
ability
yeah,
of
okay.
the flexibility of any purchasers to
Okay.
purchase for fair market
So-
value.
Not the purchase price, but that the lease that was existing was below market value.
Which would in turn impact the ability to get fair market value on a sale.
except for that mischaracterizes the testimony of Tom Stevens, who said that it didn't affect his valuation of $1.45 million. So I still don't see the relevancy, and I'll just form the objection, Judge, and if you want to decide later to consider it,
It's
we can move on.
Go ahead.
Okay. Mr. Andes, this is a string of exhibits 17, 20, 25, 26, 29, and 47.
Yes, all of these exhibits were received from Loyola Sacred Heart Foundation. They appear to be emails from personnel on behalf of Loyola Sacred Heart or dealing directly with, because most of them involve Patrick Haggerty, the superintendent of Missoula Catholic School. And all of them show that Mr. Haggerty was having social encounters with Mr. Clark. Nothing wrong with that, of course. But they also tend to show that he was sharing privileged negotiating tips with the Catholic School.
Your Honor, I'm not sure which one I'll object to, 29 for one, but I'll withdraw the objection as long as counsel is willing to stipulate that none of those communications that they want to admit into evidence were between Mr. Haggerty and anybody that sits on the public school board.
So stipulated.
Is that correct?
That's correct.
Exhibit
Sorry, there is one exception. The one email is to Mr. Clark, the 17.
Mr. Clark, is it your testimony sits on the public school board?
Oh, sorry.
Okay. So stipulated that there's no communication with anybody on the public school board.
One.
Exhibit 51.
May I inquire as to the time? Because 5 minutes left. Well, 5 minutes and 23 seconds.
Thank you.
Exhibit 51 was Loyola's answers to discovery. I don't recall the date, but when I got those, this was significant to me in several respects. In their request for admission number 2, they admitted that the elementary school was not paying rent after the Loyola acquired it. They admitted that it was no longer subject to the original lease, that had expired upon the time of sale, and they admitted that no new lease had been negotiated between Loyola and Missoula Catholic Schools.
Which finally exhibits 14, 21, and 48.
14, 21, and 48 are all either Missoula Catholic Schools or Loyola Sacred Heart Foundation. I think maybe they're all Loyola Sacred Heart Foundation documents.
How'd you get these that show the deleted part?
Ask Mr. Schneider.
Just deleted, he did that with that.
Looking at 14.
Oh, 14, he asked for what was in the file, I gave it to him. I don't like to play at the ball.
So all these are their documents indicating that they were pressuring the school district to move quickly.
Okay. Finally, did you provide discovery for all the documents supporting the case to the defendants?
I did. Exhibits, well, not sure what the exhibit numbers are. Exhibits 43 and 44 constitute some of the, these are both summaries. One is a person's sort of a witness list, preliminary witness list. And exhibit 43 is a list of documents.
And exhibit 41 as well, correct?
And exhibit 41 is, yes, also.
And 44 was your witness list, right?
That's correct.
All right, for my last question, describe the history and process of the 30B6 motion filed by the defendants, your reaction to it.
The 30B6 request notice was given to us on November 8th, 2005 from the school district, setting 30B6 deposition for November the 16th, 8 calendar days later, naming approximately, I can't remember, it was 7 or 9 different topics they wanted to depose Good Schools Missoula about. At the time, I filed an objection, which is in the record, on several grounds. Number one was the timing, because it took almost all that time simply to identify someone who could competently testify on each of those different areas. And so there was no time left for preparation. And in fact, there was no time for me to even share my file with the deponents in advance, because I had to do it from a distance from Helena. So that was one of the grounds of objection. And the other ground of objection was that, having had notice that we were using expert testimony as the primary basis for building a trust case, it was inappropriate to be asking for expert testimony from lay witnesses, and we proposed to object if that testimony was ever sought to be used, simply because they're lay people and can't testify to that.
No more questions?
May I examine?
Your Honor? Mr. Andy, you indicated that you did legal research before filing the complaint on behalf of Good Schools Missoula, correct?
Yes.
Okay. And in that legal research, did you find a legal duty that is required of Loyola Sacred Heart High School Foundation to control the process by which the public school board makes a decision to sell property?
Not at all.
Did you find any legal duty that the Loyola Sacred Heart Foundation had to control the public schools' purchase or sale of assets?
I'm not aware of any legal duty that Loyola has to control anything that the school district does.
Okay.
Make it short.
So it's fair that the Loyola Sacred Heart High School Foundation doesn't have any legal duty to control the public school board's decisions on busing, air pollution.
So stipulated.
So stipulated. So my question to you then is, what legal duty do you claim that the Loyola Sacred Heart High School Foundation breached in this case?
They didn't breach any duty. They purchased, in my view, at least, I believe there is a strong, reasonable argument, they purchased a trust asset from a trustee that was sold in breach of trust. And trust law says when that happens, typically courts will void the transaction or they will surcharge the trustee. In order to void the transaction, it is necessary, of course, to join the purchasing party. And that's typically done. It was done in the case I mentioned with regard to the sale of the Denver Post. The purchaser had to be joined to the case.
But you'd agree to me that those trust statutes that are relying on require that the foundation had knowledge that the school board didn't have the authority to sell the property.
No. You apparently don't understand the law of trusts. Under the
Unlike
law
me.
of trusts, you don't have a bona fide purchaser defense if you have knowledge of facts that would constitute knowledge of the breach of trust, not whether you knew, not whether a lawyer had advised you that you're breaching the trust.
So your position is that you cannot be a bona fide purchaser under Montana trust law if you have knowledge of facts of a fiduciary's breach.
That's right.
Okay. And what facts did the foundation have of a fiduciary breach here?
Well, they knew they were, well, we just went through them in my testimony. I'll remember them as best I can off the top of my head. But Loyola clearly knew, it was in fact, it was arguing in these documents that the lease by Missoula Catholic Schools was below fair market, and therefore that no one else would be able to purchase it. And in fact, they urged that as a grounds to award the sale to them. And there are several of these documents in here where Loyola says, are these other purchasers even aware of our lease? So, as if to say, gee, if these other purchasers are aware, why are they even bidding?
And you say that they had those communications with who?
Within themselves.
Within
Loyola,
themselves?
Yes.
So do they have some legal duty not to have communications within themselves while negotiating a purchase price?
Well, as I said before, this is your defense. You have the affirmative burden of proof of showing a bona fide purchaser defense. This is my defense to your defense.
Well, I've sat here and listened to testimony all day, looked at all the documents that you've produced, and I've yet to see one appraisal by a qualified appraiser valuing this property at greater than $1.45 million. Do you have such an appraisal?
You apparently weren't listening in court when you heard the appraiser himself say an appraisal is merely an estimate.
Okay.
Merely an estimate. And under trust law, appraisals get thrown out all the time in favor of a reasonable public process for selling trust assets.
Okay. And again, does Loyola Sacred Heart High School Foundation have any legal duty with respect to the control of the school board's process selling this property?
Your legal duty is to be a bona fide purchaser, and this evidence shows that you're not.
Okay, so when you're talking about a bona fide purchaser, you're talking about that's listed under 7234-506?
I don't put it in.
Okay, well, if I represent to you that it says that a trust commits a breach, a beneficiary or co-trustee may commence a proceeding to set aside acts of a trustee, correct?
I don't know.
Okay, to trace trust property that has been wrongfully disposed and recover that property or proceeds. Is that what you were relying on to sue Loyola and get this property back?
You read it so fast I couldn't track you. You want to show it to me?
Read it to him again.
Okay, 7234-506 says in relevant part that a beneficiary or co-trustee may bring an action subject to 7236-201 to set aside acts of a trustee, and subparagraph little I, subject to 7236-201, to trace property that has been wrongfully disposed of, and recover the property or its proceeds. Are those the provisions you're relying on?
Certainly that one, and also the common law of trust.
Common law trust. And would you agree with me that 7236-201 states, with respect to a third person dealing with a trustee or assisting a trustee in the conduct of a transaction, if the third person acts for valuable consideration and without actual knowledge that the trustee is exceeding the trustee's power or improperly exercising them, the third person is not bound to inquire whether the trustee has power or acts or is properly exercising the power, and may assume without inquiry the existence of a trust power and its proper exercise. And subparagraph 2, the third person is fully protected in dealing with or assisting the trustee just as if the trustee has and is properly exercising the power the trustee purports to exercise. So did you find any evidence of anyone from the foundation having knowledge that the school board didn't have the authority to sell this property?
The facts I've just recited are that knowledge of facts showing that this was being sold in breach of trust.
Okay. And did you develop any evidence that they had knowledge that they were breaching any fiduciary duty?
Who was breaching fiduciary duty?
That the school board was?
Yeah, the facts I just recited.
Okay. And what knowledge did they have?
Those facts.
The facts that happened in open meetings available to the public?
Yeah,
Okay.
among others.
What about the fact that pursuant to a public referendum, it was authorized that the school board could sell the property?
That's a factor to be considered along with all the others,
Right.
sure.
Okay. And you'd agree with me that it's not fair market value. The statute requires that valuable consideration be paid.
Which statute are you referring to? The bona fide purchaser?
72,
Sure,
36,
sure. But in order to use the bona fide purchaser defense, which is a defense, you have to meet all of those criteria. Of course, Loyola paid real money, I assume.
Okay.
But the question is, did Loyola do those transactions without knowledge of facts stating a breach of trust, as you just read from?
Okay, so you don't dispute they paid valuable consideration?
Nope.
Okay. So you base your entire claim on the fact that they had knowledge that the public school board breached their fiduciary obligation?
I base the claim that you don't have a bona fide purchase or defense for your client on the fact that they had knowledge of facts that the school board was not performing its fiduciary duty.
Right, we already agreed that you decided and formed the opinion that Loyola Sacred Heart didn't breach any legal duty with respect to the purchase of the Roseville School property.
I don't know of any legal duty.
Right.
None that I investigated, sure.
They had no legal duty. Their obligation was to buy the property for the best price they could get.
Sure.
All right, that's the duty they owed to their foundation.
Sure.
Okay, so to bring them in this litigation, your only theory was that you could get rescission of the property if they had knowledge of a breach of a fiduciary duty?
And that is the appropriate grounds for joining third parties to precision transactions, and has been as long as the common law has been on the books.
And you base that just on the open meeting laws and the process by which the public...
Open meeting laws has nothing to do with this case as far as we alleged it.
Okay, so you're not alleging any violation of open meeting law?
Well, you read the complaint. No.
Okay. All right. So again, I'm just trying to clarify that you're basing this just on this general knowledge that they had that the public school board was violating their fiduciary duty.
It's not a general knowledge. This was rather specific knowledge that I just cited in these documents.
What specific knowledge?
Want me to go back through them again?
Well, if you can point to any document you produced in this case of a communication between anybody from the foundation and anybody from the public school board, I'd like to see it.
I'd say that the most compelling evidence is the communication within the negotiating team for Loyola Sacred Heart itself.
Excuse me, can you repeat that?
The most compelling evidence is that which we've just cited in these documents within the negotiating team for Loyola Sacred Heart itself.
Okay, so in those documents, you believe there's a discussion within the negotiating team that says they had communications with somebody from the public school board.
I don't see what communication with the public school board has to do with it. The point is the state of mind of Loyola. If you want the bona fide purchase or defense, it's your burden to show that you've got that bona fide purchase or state of mind. These documents show that you don't.
Well, we've got adequate consideration. You agree with that, right?
We've been over that, yes.
Okay, so we've got to show that we had some knowledge of the trustees exceeding their power. Do you claim that we had some knowledge that the trustees exceeded their power?
Sure. When you know that the trustees are selling a trust asset encumbered by a below market lease, then you know that they're selling it for below market value or have reason to. When you know that you're getting insider information from the superintendent of schools about what the competing bidders are doing and when they're doing it, when the superintendent of schools gives your client insider information that, oh, you haven't exercised your option to renew your lease yet, you better do it. This was 3 or 4 days after the electorate had voted to sell the school, and suddenly it gets renewed.
Okay, and you agree, though,
in a
that
very timely fashion.
the lease is not with the foundation.
You couldn't prove it by me. The documents that are in here suggest that they're virtual alter egos of each other. At the very least, they appear to be agents of one another.
So you claim that the Sacred Heart High School Foundation is an alter ego of the Catholic Diocese of Helena?
It appears to me from these documents that they're certainly acting as agents. They have interchangeable spokesmen. They have, in fact, in Loyola Sacred Heart's, I forgot the exhibit number now, but in the letter in which they proposed the sale, Loyola Sacred Heart says, we are the fundraising arm of Missoula Catholic Schools.
And they testified to that today.
Right.
Okay, and that's Exhibit 28.
And they're not charging any lease or any rent to lease the school to St. Joseph's, according to your discovery responses.
Okay, so you talked about Exhibit 28 between the foundation and Mr. Clark, correct?
I'm looking for it here. Yeah.
Okay, and that's signed by 3 members of the foundation board.
It appears to be.
Okay, how does that relate in any way to the Catholic Diocese of Helena?
I'm assuming the Catholic Diocese in Helena and Missoula Catholic Schools are one and the same. The Catholic Diocese of Helena is not even a legitimate Montana corporation.
Right. The schools are actually owned by the Helena Catholic Diocese.
Okay.
Okay, so
And I presume that's Missoula Catholic Schools?
doing business as, perhaps, but my question is you've presented Exhibit 28 as some sort of communication between the Catholic schools and the foundation and the public board, and all I see is a letter from the foundation to Mr. Clark.
So all we're offering 28 for is to show that Loyola Sacred Heart Foundation is holding itself out as the nonprofit fundraising organization for Missoula Catholic schools, and combining that then with the other exhibit that I just discussed, which shows your discovery responses showing that the lease is now gone, that Missoula Catholic Schools is no longer paying any rent for the Roosevelt property to Loyola Sacred Heart Foundation. It sounds like the fundraising role is still continuing.
Right, and you raise an interesting point. If the foundation is not charging a lease, then isn't the value of the property then actually less than 1.45 million?
To whom? Value to whom? To Loyola?
Well, you made the claim that this property was subject to a below market lease, and because of that, 1.45 million wasn't the proper fair market value. And my question to you is, if the foundation was going to charge no lease, their lease was for $0 per month, wouldn't the building actually be worth less to them than somebody buying it subject to the below market lease?
That's a really good argument from an economic standpoint, and it makes sense if you're talking about an arm's length transaction. I'm suggesting that that evidence instead is much stronger evidence of something not an arm's length transaction, which is to say that Loyola Sacred Heart Foundation appears to be fulfilling its role. It's raising money for the Catholic schools of Missoula by charging them no rent.
Right. And that's what they're charged to do.
But that gives them an advantage in purchasing the property, because their very purpose for purchasing the property is so that they can not charge rent to the Catholic schools. So they had an advantage over any other bidder.
How does that give them an advantage? They're losing money compared to any other bidder.
They're not in the business to make money. They're a nonprofit corporation who raises money for the Catholic schools. Sorry.
But you'd agree that they did pay 1.5 million.
Beg your pardon? You're done.
Okay.
Did you have questions?
I do. Your Honor, thank you. Mr. Andes, you're basing most of these arguments on your contention that the general trust codes apply to school district trustees in Montana.
That's correct. We've gone around about that before, haven't we?
You have, and Judge McLean actually found that you provided no persuasive legal authority to support that. Is that correct?
He found that.
He did. Okay. And you appealed the dismissal to the Montana Supreme Court. Is that accurate?
That's correct.
Okay. And the Montana Supreme Court upheld the dismissal based on a statute of limitations found in Title 20 of the Montana Code. Is that accurate?
Actually, if you read the opinion of the Supreme Court carefully, they said this is not a statute of limitations decision. This is an exhaustion of remedies. Exhaustion of administrative remedies.
Which brings me to a question that has been bothering me ever since I got this case. You are faulting the plaintiffs for bringing this case, correct?
Absolutely, Your Honor.
Fault in the sense that you want to be paid your attorney fees.
Yes.
And you claim you are the winner. And you are.
Yes.
Your Honor, actually not true. We're not necessarily claiming that we're the winner. We're claiming that this case was frivolous with respect to the foundation.
No, you're claiming it was thrown out.
The
And
Montana
so,
Supreme Court dismissed it, Your Honor.
right. But what is interesting to me is that I've got 1, 2, 3, 4 lawyers here, and until it got to the Supreme Court, nobody came up with this, you didn't exhaust your administrative remedies. That's why the Supreme Court threw it out. They said he didn't exhaust his administrative remedies. And nobody thought of that. So how can you be the winner?
Well, Your Honor, I think there are a variety of reasons that you can look at.
Okay, let's start with number 1, first reason.
Okay. I did raise that issue.
In the district court?
No, Your Honor, I didn't
I
file a
know,
motion
that's
to
just
dismiss.
what I said.
didn't file a motion to dismiss.
Let me, I only get to talk.
I know, but I'm not.
It only, yeah, you're out of time. It only gets, when you're out of time, you know, when time goes by. But
Yeah.
stop, the clock stops when I talk. It only was raised at the Supreme Court. Why didn't you raise it at the district court? You would have won there on that basis.
Your Honor, Judge McLean didn't find on that basis.
Well, that's not what I said.
I know.
Address my questions, please. My question, excuse me, my question was, why didn't you raise it at the district court? Like you say to him, you didn't exhaust your administrative remedies, we win. You didn't say that.
I chose not to file a motion to dismiss that case because Loyola had filed a motion to dismiss. I was focusing on the motion for summary judgment.
And you thought of it?
We had talked about it. I can tell you, yes, I talked about it, yes.
About the administrative remedies?
About having to exhaust your remedies by filing a complaint with the county superintendent.
And you didn't raise it?
I did not at that time, no, Your Honor.
So that's what I'm thinking is, you say to them, you got your case thrown out because you didn't exhaust your administrative remedies, so says the Supreme Court, but you never thought of it, and you never thought of it, and they never thought of it. How are we going to fault them?
I thought about it because I filed a brief with the Supreme Court making that exact argument, and they accepted my argument.
And that's a good job for you.
Thank you.
Why wasn't it done at the district court level?
Because
And maybe they would have seen like, uh-oh, we really messed up here, and they wouldn't have appealed.
at that time, Your Honor, when I was looking at the actual complaint, the allegations in the complaint that were based on trust code, that were based on a violation of the Montana Constitution, generally, since the trust code doesn't apply to schools, which we now know, thanks to the Supreme Court, those wouldn't have been an
He sure
exhaustion.
believed it though, didn't
He
he?
sure did, and I don't...
And he's wrong.
He's wrong, he is. But at the time, because those weren't items that would have fallen under the county superintendent jurisdiction, I didn't believe it was appropriate at that time to file that motion. As we went further along in the discovery and it became apparent how the claims were actually being made, and the fact that none of the actual members of Good Schools Missoula had the facts, but Mr. Andes, they thought Mr. Andes had the facts, but they weren't sharing that information with us. Then it became more appropriate for us to go back and look at the actual basis of the complaint, which we knew couldn't be based on trust law, which we knew couldn't be based on a constitutional violation based on the evidence they presented at that time. Then it became apparent after the district court had issued their motion to dismiss that based on the arguments they made during their depositions and during discovery, that it was appropriate at that time to raise county superintendent jurisdiction.
That's it.
Do I have any time left to ask
Yes,
Mr.
11 minutes left.
Okay.
11 till 4.
You know, I'm going to just, I know that everyone wants to make a closing, so I'm going to do this.
Don't waste your time with the closing.
Okay, then I'll take my time then. Okay, Mr. Andes, you were present obviously when Mr. Funch testified that he thought you had most of the information regarding this case. Is that accurate?
That's what I heard, and that also was accurate.
Okay, so when you were preparing Mr. Funch and the Smith sisters for their 30B6 depositions, why didn't you provide them the information that you had gathered and claimed to have gathered before you even filed this case?
Because there wasn't time, he only gave us 8 days' notice to designate them and prepare them.
Okay, and during that time, you didn't have any ability to even, for example, tell Judy Smith, hey, I talked to that appraiser in Austin, here's what he says.
Not in 8 days, no. In my career, 30B6 depositions are typically noticed at least a month out, typically more.
Okay, and then why didn't you refuse to go through with the deposition?
That's not my choice, that's your choice.
Okay.
I filed an objection, you chose to go ahead.
Did you ask for a continuance?
One doesn't ask for a continuance in those situations. I could have made a motion to
What one
suppress.
should do is to pick up the phone. With all due respect to lawyers that spend their life fighting, pick up the phone and ask her. I can't get ready. People are all over the place. I'm not going to try to put information into their head. Give me a little break on the time. Did you ask her that?
I don't recall.
She seems to imply you didn't.
You didn't. So when the case was filed then, you were the only individual that had the knowledge necessary to file this complaint. Is that what you're alleging?
I was the only individual who possessed the composite of knowledge, that's true.
Okay, and you claimed earlier that you had bushels of testimony coming to you, I think is how you described it.
Bushels of stuff, documents.
Stuff.
Yeah.
Okay, and between the time that you got that information, which would have been prior to the filing of the complaint in early April to November, had you not had the opportunity to sift through that information and distill it for your members, or for the members of Good Schools Missoula?
No, I'm generally not in the practice of briefing my clients on, especially in cases of this complexity. I try and keep them up to date on what's happening. But as far as writing them a term paper about all the facts and law of the case, I generally don't do that.
Okay, so is it your testimony that the individuals who are members of Good Schools Missoula could not have competently testified about the facts underlying the allegations in the complaint?
No, and you shouldn't expect them to because they're not experts. And this case requires expert testimony.
There's nothing in this case that requires factual information?
Oh, sure. like most complex cases, this one requires a mixture of lay facts, documentary facts. In this case, I was planning, if this case had gone to trial, reviewing the videotapes or MCAT videos in some length of meetings, and it requires experts, so that a composite of testimony, like most complex cases, require.
Okay, and did you have an appraiser give you an opinion that the appraisal that was performed by Mr. Stevens was not accurate in this case?
I did not, because I decided that Mr. Stevens' advice that the board ignored was probably more important than trying to attack his worthy effort in a short period of time, as he described this board.
And you heard Mr. Stevens testify, I believe, that regardless of whether or not those lots had been developed and front part just used as a school, it still didn't change his estimate that fair market value was $1.45 million.
I think I heard him say that, yeah.
Okay, and you're aware that the foundation paid more than the appraised value of the property, is that accurate?
Of course.
Okay. You had some experts apparently that you were going to call. One of them was Don Ryan, is that accurate?
That's correct.
What does Don do for a living?
I don't know.
You don't know. On what basis would he have been an expert?
He'd been on the school board for some period of time, and in particular, he'd been on the school board there during the period of closing and sale of, I can't remember the name of the school there now, in Great Falls. But,
And you would suppose that makes him an expert to talk about what?
well, the reasonable prudence standard with regard to trust law requires that one looks at the example of what a reasonably prudent trustee would do, in a similar situation. So I wanted to see what a reasonably prudent trustee would do in similar situations.
Under general trust codes, which we know don't apply, correct?
I don't agree with that.
You don't agree with that?
The Supreme Court didn't say that. They ruled on an issue of procedure only.
Okay, so you still think general trust codes apply?
Well, I'd like to know what you make of that language in Title 20 that talks about trust
Oh,
operations.
that's what I asked you. Do you believe, sitting here today, do
I
you
do.
still believe?
You guys
Yes.
are talking on.
Sorry. Okay. And you're going to call Alan Nicholson as an expert, is that
That's
correct? Okay. And Alan is the developer of commercial private property in Helena, is that accurate?
That's correct.
Okay. To your knowledge, did he have a chance to come down and review the appraisal? Did he do his own appraisal?
He reviewed the appraisal at some length.
Did he produce a report for you?
We hadn't gotten that far.
Okay. Had you had conversations with him?
About half a day, yes.
Okay. But you didn't impart any of that knowledge to the Good Schools Missoula members who you set up as 30B6 opponents?
Didn't have time. And I did impart that information to them in general terms before we even filed the case. I said, here's the information that I've gotten from them.
Were you surprised that none of them were able to recall that or testify to that when you were deposed?
Not really. It's hard to remember that kind of detail. This is a detailed case, so it's hard to remember detail.
Did you explain to them that Good Schools Missoula was bound by their answers they gave during these depositions?
I'm sure I did, yes.
Okay, and how much did Mr. Nicholson say the property should appraise for?
I wasn't asking him for that question, so he didn't answer that question.
Okay. What was the basis of your conversation with Mr. Nicholson?
The basis of my conversation was, well, I was coming at it from a trust law standpoint. A trust law standpoint says, I'm sorry, I went too fast. From a trust law standpoint, what you want to look at is the process to see if it's reasonable, it's reasonably prudent in particular, to see if it has the indicia of obtaining fair market value, and to see if there are any breaches of loyalty. From my perspective at that point, not being an expert on appraisals, although I tried to digest it as best I could, I wanted the view of someone who looks at these things day in and day out for his whole career to see what his take on those issues was.
To your knowledge, is Mr. Nicholson an appraiser?
Oh, no.
No. Okay. And your complaint didn't allege any violations of Title 20. Is that accurate?
We allege violations of Title 20 to the extent that the two sections I cited in Title 20 impose trust duties on trustees. I think that's why they're called trustees.
Does the complaint make any reference specifically to Title 20?
I believe it does. I could be wrong, but I think it does.
I read through the Supreme Court opinion, and I didn't see in there, or did you see in there where they totally rejected his trust theory?
No, Your Honor, but had the trust theory applied, then the county superintendent's avenue would not have been the appropriate avenue for those folks to go.
Did they say that?
No, I think it's implied in their opinion. They rejected the
You agree with
8-year,
that?
I don't know.
obviously.
I'm looking through it, and he's standing firm on his trust theory.
I'm sure he believes it, but the reality is if the trust theory had applied, then the county superintendent appeal would not have been available to those folks for a challenge because the county superintendent jurisdiction is limited to particular topics. Arguing over whether or not the duties of a trustee under trust law doesn't fall into that at all. Had it fallen into that, it would have been under the statute of limitations of 8 years for the general trust code, and that would have been a whole different avenue of appeal.
And if it would have, they could then have used either one of those theories, the administrative ruling, administrative decision, limitation has gone by, or alternatively, the trust theory. And if he fails, as was the case here, on the administrative, 30-day administrative rule, the Supreme Court still could have said, but you're still good on the trust theory, keep going with that side of the case.
Exactly.
You agree with that?
It doesn't quite make sense to me, so I guess I better say no.
Right.
Can I continue?
Mhm.
Okay. Mr. Andes, did you consider filing a county superintendent appeal in this case?
I did not.
You did not. Were you aware of what the county superintendent jurisdiction is to review a decision on public school?
I'm not.
Okay. So you brought this case under the theory or the basis that general trust code applies to school district trustees in Montana. Is that accurate? Okay. Is there any case in the state of Montana that says that?
Not that I'm aware of.
Okay. And is there any particular section of Title 72 or any of the general trust codes that say these rules apply to school district trustees in the state of Montana?
I cited two sections of the Title 20, both of which make specific reference to the fact that the trustees shall hold school district property in trust.
Right.
Under trust law, those words are magic words. Those words mean trust law applies, and you should act as a trustee.
Okay, but that was your interpretation, is that correct?
Of course, that's
Okay.
what lawyers are for. That's why we all have jobs.
And in fact, didn't you at one point state that you shouldn't be penalized for making a good faith effort to expand the trust law?
I don't recall our words, but we probably could have used those words.
Okay,
He did it in his findings, I think.
okay. So was it your intent to expand the trust law through this litigation?
I wouldn't argue that it's an expansion. I'd argue that it's, if I use the words, I use the words, fine. But I wouldn't see it as an expansion. It's simply giving life to the words that the legislature put in Title 20.
Okay. And you're asking for, essentially, for the public school to pay for your attempt to broaden the trust code as it currently stands to now apply to school district trustees in the day-to-day operation of the school business.
I definitely would not use the word broad. And Title 20 says you shall hold this property in trust. That has to mean something. Unless if those words mean anything at all, I don't see what else they could mean, but that trust principle apply.
But you claimed you were undergoing a good faith effort to expand this area of the law.
If we use the word expand, we use the word expand. But I would broaden, I would say is a very different word. We can quibble about words though, I guess.
Okay. Well, so when your folks testified during depositions, they didn't have sufficient information, but were relying on the information that you had gathered. Is that accurate?
To the extent that we were able to share the information, sure.
Okay. And on your knowledgeable persons list, did you list yourself as someone who had the basic facts and information necessary to defend this claim?
No, of course not. Trial attorneys never do that because trial law firms typically prepare cases, become the conduit of information for collecting all the information, and then proceed to try the case. If I were to list myself, you would have had to depose me, which would have been a problem for you, because then you couldn't have used me as a witness.
Right, but I can't also then defend the case if you won't provide that information. Isn't that accurate?
I provided you lots of information, exhibits, was it 40 and 41?
But you chose
Gave
not to
you
divulge.
great detail of information at the time we had it. We updated our discovery responses not once but twice.
But you chose not to divulge that you were the only individual that had the bulk of the knowledge necessary.
Actually, I probably said that in the course of the depositions, if you want to read all those transcripts. I objected to many of your questions as being asking the wrong, in fact, I think I used almost these exact same words in one of my objections. You're asking the wrong questions to the wrong person because these are lay people, you can't get expert testimony.
Did you ever identify yourself as the individual that had that information?
Of course not.
Okay, that's all I have.
I'm looking at the opinion, it looks to me like the Supreme Court drove right by Title 72, the trust law, as if it wasn't even there.
True.
What does that mean?
Your Honor, I think it means that the Supreme Court was agreeing that Title 72 and how it's applied to trusts and to trust property in Montana are not applicable to the publicly elected officials who act as trustees in the state of Montana. They're governed by Title II and Title 20. Title 72 creates a whole different group of duties and obligations that have never before been applied to a public school trustee. Mr. Andes was attempting to expand the law. Had he been successful, the court would have said, you're right, continue down that path. They didn't do that. And now we're coming back and saying we shouldn't bear the burden of his attempt to expand that law.
Do you ever get the sense that they didn't address it if they, under the idea of why address something unless you have to?
I think they would have had to have made mention of it if they were going to find the trust law applied. I think they were very clear that decisions of school board trustees are governed by Title 20. And if you want to take issue with anything that has to do with what a decision a public school makes, there's a process to follow.
All right, thanks.
Thank you.
Council, I'll take the matter under advisement.